Thank you all very much for joining us today. We have a very exciting and timely webinar today. My name is Chris Van Dyke. We are thrilled to have Bob Hoban with today, and in a moment I'll say a few words about Bob. But firstly, just a couple of housekeeping announcements. This is scheduled for an hour. Bob and I met this morning, and we realized very quickly that we could have had our fireside chat and for 3 hours. So we're going to be very mindful of the time. We do also want to allow for some questions. And please feel free to put questions in the chat. Raphael, one of our team members from our business development team, is here with us, and he's going to be keeping me and Bob in line, and will let us know. And if we can also, depending on the question, we can take questions throughout our discussion. I would now like to more formally introduce Bob Hoban. Bob, I knew of you, I think, 12, 13 years ago, way back when I was a general counsel at a financial institution. And, your name stretches to every state in the country and many countries beyond the US. And I'll just add a little bit to that. Bob has been a pioneering force in the cannabis industry for over 16 years, shaping policy, business strategy, and legal frameworks worldwide. Bob is recognized by Forbes in 2022 as one of the top 42 cannabis industry power players. Bob has advised governments, businesses, and investors on the global cannabis market. As a leading commercial cannabis attorney for nearly 17 years, Bob represented industry titans and developed strategies for market expansion and diversification. He has advised over 30 countries, 10 US states, and numerous local governments on cannabis policy, including his current work with the Kingdom of Morocco. Bob is a professor at the University of Las Vegas's Cannabis Policy Institute and has developed cannabis curricula at multiple universities. Bob is a regular Forbes cannabis columnist, and he has hosted the Hoban Minute podcast, which produced over 200 episodes and won industry awards. Today, Bob serves several international governments and works each day as a fractional chief strategy officer and president for international cannabis supply chain companies through his consulting firm, Greenbridge Proven Strategies. He continues to influence the global cannabis industry through policy leadership, strategic consulting, and market innovation. And I realized after I'd done that I should have given my introduction first, because that is a very, very hard act to follow. uh, so I was a financial regulator, worked for the Maine Bureau of Financial Institutions for 8 years. And during my last year there, the FinCEN guidance, which as many folks here know is the Bible for cannabis banking, was issued. And as a regulator, I advised many of our regulated entities on the FinCEN guidance and what that meant back then. It means something very different now, as many of you know. Later in 2014, I jumped ship and became a general counsel and BSA officer and chief risk officer for a financial institution in Maine. We were one of the first financial institutions in the country to have a cannabis banking program, and it became very profitable for us. When I left, it represented a full 25% of our total ROA. And for the last year and a half, I've been with Cogent Law Group in private practice, and I offer my general counsel services to banks and financial institutions in Maine, but the focus of my practice is on advising financial institutions who are thinking about getting into the cannabis banking space, advising financial institutions who have a cannabis banking program but want to expand into the lending space, assisting financial institutions who may have gotten into a bit of trouble with the regulators on their cannabis banking program and need some remediation. And then finally, working with financial institutions who may have very well developed cannabis banking programs, but are looking to gain efficiency with those programs while at the same time remaining very compliant. So that's it for me. I do want to, during our talk, when Bob and I were having our prep session this morning, Bob informed me of some very, very important news. So I had kind of developed a bit of an outline, but I really want to jump into this rather important news that Bob has. So Bob, if you mind, I'm going to turn it over to you and we can kind of go from there.
No, I appreciate that, Chris, and thank you for the kind intro. It's my pleasure to be with you on this panel, and really looking forward to it. And as we talked about, as you mentioned, we could talk about these things for hours, and there's a million topics to cover. But we'll try to keep this focused, and with the quote unquote news, let me try to frame this so that we can, when we talk about specific topics, we can talk about these different alternative scenarios. So, of course, the President of the United States, President Trump, has indicated that he is considering the reclassification of cannabis. Just 2 days ago, a inside White House staff press was quoted, remained anonymous, but was quoted as saying that the president has indeed decided on reclassifying cannabis. Using the word reclassifying is very interesting because there have been murmurs, if you will, of descheduling versus rescheduling. And I think that that's a really, really interesting framework to have this discussion because what we saw during the President Biden administration was a dedicated announcement, an HHS pathway, a rulemaking process that was begun and ultimately stalled out or was paused, if you will, because of political changes. But that was moving the treatment of marijuana under our Controlled Substances Act towards Schedule 3. Schedule 3 having far broader applications medicinally, joining the ranks of things like ketamine or Tylenol with codeine, things that are maybe more household recognized than heroin and cocaine that are in the higher ranks of schedules. Where marijuana currently sits is Schedule 1, meaning it has no recognized medical use and it has a high potential for abuse. Now, there are some sort of caveats to that designation for the development of drugs, but that's not what we're here to get into. We're here to talk about what happens if it's rescheduled. Now, I note the word reclassified because, again, the interesting discussion point is the industry has clamored for descheduling. They've said rescheduling really doesn't do much. Rescheduling provides 280E relief, which we can talk a little bit about, and we will, meaning tax relief, but it doesn't really provide much of a pathway for existing state-based regulated operators. And then, of course, there's a fear that this will pave the way for big pharma. So looking at Republican or Trumpian ideology, for example, it tends to value individual rights. The Republicans tend not to be as cozy or respectful of the pharmaceutical complex, big pharma, if you will, as the Democrats have been. And this government appears to be largely a transactional political government versus, I don't know how you describe it otherwise, but it appears to be transactional, meaning let's create economic opportunities that last for the short term, regardless of what will happen in the long term. And, frankly, based on where we are economically as a country, where the industry is, we could use that. So descheduling would accomplish that goal. So let's just talk about the difference between rescheduling and descheduling, and then I'll sort of throw it back at you with just a broad question to start this, Chris, is rescheduling is moving it from Schedule 1 to, they say, Schedule 3, could be lower. But Schedule 3 has been all of the talk. And again, it sits amongst some of those other known drugs that we talked about. Now, descheduling is not a formal term necessarily, but what that would mean is removing marijuana from the Controlled Substances Act altogether, descheduling it, taking away Controlled Substance Act oversight, DEA oversight of this plant. And descheduling would appear to be the clearest path of legality because it would say, we don't know what it would say if this were to occur, but if this were to occur, then it would mean that there's no federal prohibition of the use, cultivation, distribution of marijuana, or at least no laws directing it one way or the other. Now, in that event of descheduling, the states have tended to fill the void based on their quote unquote police power. In other words, their ability to look out for the health and safety of their citizens by creating regulations over things that are descheduled. For example, alcohol is not a Controlled Substances Act ingredient, nor is tobacco. And those things tend to be regulated in part with overarching standards at the federal level, but then implemented and enforced at the state level. So descheduling would be a much, much, much better fit logistically, because if you descheduled cannabis from the Controlled Substances Act, then you'd have the state-based systems in place already to handle the regulation. And then it doesn't have to codify all uses of cannabis, of marijuana, as medicinal uses. Because remember that most of our systems in the US are adult use, recreational use, meaning they're not even trying to say that this is for back pain or any sort of physical or medical condition. They don't have to. So descheduling would be the most appropriate pathway. There's been word from the White House that that's the direction that this would go. And there is an indication that this would fit clearly with these Trumpian Republican ideologies. So rescheduling would be far more restrictive. So with that said, Chris, I kind of throw it back to you with your banking and regulatory experience, which is so impressive, is which environment would a bank favor? Because descheduling means there's no rules. It's very clear that this is legal, so there's no risk of illegality, but there's no rules to follow, and banks like rules. Whereas rescheduling would say it's treated as a lower class of a drug, but there's a bunch of rules you have to follow to comply.
Yeah, so I am so glad that we had this conversation earlier this morning because I've had a little bit of time to think about this now. The with the rescheduling, if it were scheduled to, Schedule 3, I think that certainly would mean some kind of perceived de-risking on the parts of banks and credit unions. I think more boards of directors would be interested in this, given the fact that I think reputational risk would be diminished to a certain extent, although I'm not sure there's much reputational risk to start with nowadays, given the fact that cannabis is so prevalent. If it were descheduled, as you say, Bob, that and I think going back to perceived risk, I think the perceived risk is probably diminished even further. But at the same time, as you suggested, it does create a bit of a vacuum in terms of a regulatory vacuum, I think, for banks and credit unions. As I mentioned, at the outset, all these banks and credit unions are subject to this Bible, the 2014 FinCEN guidance. And I think
And Chris, I told you I was going to interrupt you at this point.
yeah,
Please,
no,
just
please.
for the benefit of the whole, just talk about what FinCEN is, just to place it into context, because not everybody understands our acronyms,
Yeah.
our
Yeah, no,
agencies.
I appreciate your interrupting me. So FinCEN is the Financial Crimes Enforcement Network, which is kind of a bureau within the U.S. Department of Treasury. And they, back in 2014, they put out this guidance. It's guidance only, it's not law, regulation, or anything like this. And it was basically permissive but cautionary guidance to banks and credit unions, basically saying, hey guys, banking cannabis is basically a risk management decision. However, if you choose to bank cannabis, this is the guidance that we want you to follow. And the guidance was based in large part off a memo that James Cole wrote about 7 months earlier, the Cole Memorandum, which basically instructed U.S. assistant attorneys general throughout the nation not to focus their enforcement priorities on legal state legal cannabis businesses. So that's what FinCEN is all about. And frankly, in legal circles, there's been some criticism lodged against FinCEN for not having already revised its FinCEN guidance, given the fact that cannabis is legal in one form or another in close to 40 states. And there are, quite a few compliance burdens uh, that are associated with the FinCEN guidance. And because it's guidance, there's no definitions and there's no official staff commentary like you would find in a regulation. There's also greater uncertainty on the part of financial institutions in terms of what the regulatory expectations are for banking cannabis. And I think what's happened over time, Bob, is that examiners go from one financial institution to another, and they see some best practices developing with some of the better financial institutions, and these in turn have kind of become regulatory expectations, although you can't find them spelled out on a piece of paper anywhere. And so that, to my mind, that's actually one of the greater compliance or regulatory risks associated with cannabis banking. So if descheduling were to occur, and we don't know this for sure. I mean, I was trying to predict the Safe Banking Act would pass 8 years ago, and talking to my CEO at RFI then that this would represent some de-risking. And of course, I was crying wolf back then, and I've stopped trying to predict Washington. But if descheduling were to occur, I do think that a greater number of financial institutions would be jumping into the market because of this even greater perceived de-risking associated with cannabis. Uh, I think it certainly would put greater pressure on FinCEN to revise its guidance. One of the big criticisms we've heard about the FinCEN guidance is this uh, requirement that financial institutions file suspicious activity reports, SARS, on a rolling basis, even if there's no actual suspicious activity involved. And I think because of the federal illegality, and I think, and again, I don't know this for sure, but I would imagine that this is presenting FinCEN with a lot of junk data that they really, and I question the usefulness of that data on the Marijuana Limited, what are known as the Marijuana Limited filings. So I think it's a whether it's rescheduling or descheduling. Again, I think there's to put it in a nutshell, Bob. I think there's certainly more de-risking, or at least perceived de-risking. You still have the FinCEN guidance out there, which until that gets revised, financial institutions will have to follow. And as you rightly point out, it also creates greater uncertainty for banks and credit unions. I think even with descheduling, it's still that these CRB accounts, cannabis related business accounts, I think there are always going to be some elevated risk associated with them. Uh, um, because I mean, there's still going to have to be some, state regulation, not selling prohibitions against selling from bars, and I think it's going to become a little bit more akin to alcohol and tobacco state regulation. Um, I also think and I'm probably waffling on for too long here, but I also think that it's going to become a little bit more like hemp in that the banks and credit unions are going to have to pay much closer attention to the what regulatory regimes are in place at the state level for cannabis and making sure I mean, they already have to do that now, but I think that that emphasis is even greater, will even be greater now if it gets descheduled. Um,
And
I
Chris,
also think, yeah, go
yeah.
ahead.
No, no, please finish your thought.
So again, I think there's going to be some uh, with rescheduling and descheduling. I think there's going to be some pressure on pricing because I think more financial institutions are going to be jumping into the market, and that's a good thing. Competition is a good thing. These cannabis companies are under so much financial pressure now because of all the compliance burdens, 280E, and so forth. Um, I think there's going to be some pricing both on the both fee pricing on the depository side, but also pressure on interest rates. But the other thing that you pointed out is that 280E goes away, Bob, with rescheduling to if it goes to three or with descheduling. And that is going to be very important because CRB's profit margins will increase significantly because, of course, with 280E, they're going to be able to deduct business expenses, and that is going to make them much more attractive prospects uh, on the lending side for banks and credit unions. So that's kind of my take with all of that.
I
Um,
looked at it, and I'm glad you mentioned the hemp side of things, and I think that's
yeah.
maybe where things are a little bit counterintuitive, right? Hemp is presently a descheduled compound. Every single part of that plant, including the THC up to a certain threshold, is deemed not scheduled any longer, and that's expressly stated in the law. And banks, mainstream banks, have elected by and large to bank hemp businesses, even though the knock is that they're not always regulated. Now, there's a number of states with robust programs, but not every state has a robust regulatory framework or a production framework or a consumer protection framework or an age gating framework for hemp derivatives. Yet they're because it's descheduled, the banks have decided to take the risk and jump in. And so if marijuana is descheduled, it would seemingly put the state-based systems as the regulatory compliance piece that the banks would look at. But again, to your point, we really don't know where it goes. And I do want to come back to 280E, but at Seed Trust, we're really interested in the risk and the lending piece of things. Um, and I'd like to talk about that for a minute. It's been said that banks aren't really banking unless they're lending. Taking deposits is one thing, and many of the banks that take deposits from the marijuana sector of the cannabis industry have charged, almost punitive fees to comply with their SARS reporting and so forth and so on, a number of different regulatory requirements that you know far better than I. But at least that's the guise for charging, sometimes thousands of dollars a month for access to depository accounts. But if they're not lending, it's been said they're not really banking. Banks want to take deposits, but they also want to be able to lend that money and lend to that industry. So in looking at lending, I think that's an interesting piece because it's been described as a debt wall that's coming. Bo Whitney from Whitney Economics, a number of publications have talked about this debt wall. We at C Trust look at this debt wall, and the debt wall means that, you know, uh, so many cannabis, marijuana related companies have enormous, obligations to pay back loans, and they're either coming in balloon payments or they're coming in increased interest rates, but it's all coming to maturity in the next year and a half to 2 years. And that seems like a doom and gloom scenario, but maybe re or descheduling sort of makes interest rates, as you point out, and the lending environment more friendly. But even short of that, you would think with a forthcoming debt wall with, interest rates at sometimes 20, 30, maybe even usury style rates above 38, 40% in some cases, that banks would want to come in and refinance that. So I guess what I'm thinking about and what we think about at Trust is do do the banks want to wait for the formal signal of rescheduling or descheduling? And how are they going to examine compliance so that they can refi that existing debt, let alone place lines of credit out in the marketplace for equipment and inventory and payroll? What's your prediction, or how do you see lending evolving? Are banks waiting for the next move, or are they just saying we can't wait any longer? We got to jump in and refi this debt wall because that's how we're going to make some money?
Yeah, great question. And let me start with first principles first. Going back to the FinCEN guidance, the FinCEN guidance doesn't even distinguish between lending and depository services. It just talks about financial services. Having said that, there are, some additional risks associated with the lending. You're creating a stickier relationship, which is both a positive thing, but also could be a negative thing if things go south with the CRB, both from a financial point of view and also if they get into trouble with their regulators. I have always been of the view that if a if a bank or credit union is already, you know, doing cannabis banking on the depository side, they've done a lot of the heavy lifting with the compliance and the BSA obligations that they have. The real risk is in the underwriting risk, and I am like you. I'm familiar with the what C-Trust has to offer in terms of mitigating both the financial risks with its ongoing monitoring, but also the non-financial risks of the with the CRBs and using C-Trust basically as a tool to uh, catch things before they become an underwriting problem for banks and credit unions. So I think that a lot of I think that's it's I think the number of banks and credit unions that are currently serving CRBs is in the 800s somewhere, which is a pretty small minority of the overall number of banks and credit unions. And of those 800, I think it's a very, very small number that are offering lending services. I think it's a huge opportunity for banks and credit unions. And I think it's a huge lost opportunity for banks and credit unions if they're not thinking about cannabis lending now, if they're already in the cannabis banking space. So they should be, their boards, again, it's a risk management decision that's up to the boards and the CEO. But at the end of the day, um, people always talk about the risks associated with cannabis banking and cannabis lending and so forth, but it's a two-sided equation. What are the lost opportunity risks of not banking cannabis and not offering cannabis lending? It's certainly, from a bottom line perspective, it's a great opportunity. It needs to be done thoughtfully. It needs to be done with the right partners like C-Trust, other third-party service providers. But now is the time. Now is the time for banks to be discussing this for at the board level, and for moving forward. These things are move incrementally. I know, I've worked at a financial institution long enough to know that these decisions are not made overnight. But these should now be ongoing discussions, particularly in the current environment. And even if even if rescheduling or descheduling, it turns out that uh, doesn't come to fruition. I think that if they've been doing it on the depository side for a number of years, they know their CRBs very, very well. They should be considering lending. And I've spoken to some boards already, and many of them are on the fence, but they're talking about it, and that's the important thing, I think.
Chris, and again, obviously, you're not going to reveal any confidences as an attorney, but I just wonder what's the general sentiment from these banks when they consider lending? Is it that the risk is unquantifiable a word? They don't really fully understand the universe of how to measure the risk, um, or is it that they're worried about like a RICO violation, aiding and abetting? In other words, for those of you listening, in other words, are they worried about getting locked up in some sort of conspiracy to violate federal law because they're working with a Schedule One substance seller, or is it a little bit of both?
Yeah, again, really a good question. The legal risks associated with cannabis banking, you mentioned a couple of them, the potential aiding and abetting and the RICO violations. Those already exist if they're doing the depository services. I've always viewed, and again, this sounds very strange coming from an attorney, but I've always viewed the legal risks, the risk of prosecution from a state or federal prosecutor, uh, 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 against a bank. I've always viewed that circle of risk as being the smallest circle of risk in my Venn diagram of risks. That the legal risk, there hasn't, and history is on my side. I mean, it's not been a bank or credit union that's been prosecuted for banking cannabis. And we were going to talk a little bit about why we got into this space, and I guess now's my opportunity. I mean, there are some great public policy reasons for banking cannabis. And prosecutors know these reasons, and that's why they haven't gone after them. There's the public safety issue. You're safely vaulting all of this money. You're creating an environment which uh, uh, enhances fiscal responsibility because there's now a paper trail with the bank accounts and so forth. And federal prosecutors are very well aware of those public policy arguments for banking cannabis. And no uh, prosecutor is going to make a name for him or herself by going after a bank for banking cannabis. It's really, as an attorney, I can't say that it's not going to happen, but I can tell you, in my view, my humble view, that the chances of being prosecuted for a RICO or an aiding and abetting violation are minimal in the extreme. That's the language that I use when I talk to boards. That's my view on that. And I think with the current environment, we're clearly moving toward or descheduling. The That very minuscule, that small chance of prosecuting gets even smaller.
Sure, sure. And by the way, I see a question in the webinar chat bar. If anybody has a question, please put it in the Q&A button, and if it's timely, I'll try to integrate it, or we'll try to integrate it into what we're talking about. But there does appear to be a question there related to digital currency, blockchain technology, and that is sometimes a lot of people don't understand it. A lot of people try to stay away from it. A lot of people think that it raises red flags when you mix a novel technology like in a blockchain and digital currency with a novel industry like cannabis. Um, how has, if how has the Trump administration treated digital currency and blockchain technology? And do you see banks willing to embrace that? If a cannabis company comes to the table and says, I've been working on the blockchain, and I've had digital currency accounts for a number of years. Is that a red flag? Is that a good thing? How does that look for compliance with banks?
So I think that's very much a moving target. And I am not a digital currency legal expert at all, but I do know that For this question, I would have said no. That's kind of piling risk onto risk. But for the last couple of years now, banks are now embracing digital currency, a stable coin under the Genius Act. So I do think that there is some enhanced risk with CRBs also using digital currency. Although as I said a couple of years ago, I would have said that's too much of a red flag. I think now it's really a question of, being able to understand the business model, how that's being used, being able to understand the, what transactional data is going to is not going to create any red flags for your BSA department, and having those full and frank discussions with the folks with the compliance folks at at your financial institution. Digital currency is like cannabis. It's been here much longer than people realize, and it's not going away. So I think at some point in time, this what you've described is inevitable, or what the questioner has asked is something that's inevitable, and something that banks and credit unions should be looking at and not just saying no to now.
For example, Chris, I'm involved in a number of international transactions in the, what I'd call the global cannabis supply chain. And for example, if a German company is buying cannabis lawfully from, the country of Colombia in South America, a lawful transaction on both sides, um, and the Germans pay in euros, for example, and then the Colombians want to get paid in pesos, Colombian pesos. And, so we've worked with some platforms that sort of instantaneously take that, X number of euros, convert it instantaneously to digital currency, and then at the same time convert it to a Colombian peso. And, there's of course an exchange fee or an underwriting fee for those types of transactions. But then that account sort of remains out there in the ether. That peso doesn't necessarily end up in a bank in Colombia unless and until that person that owns that account in the ether wants to put it into that bank, which in theory creates a taxable event of some sort. So it gets even more complicated when you look at the international side of things. But I also think that that's a relevant conversation. We've got about 20 minutes left, and I do want to sort of touch on capital markets. I want to touch on bankruptcy and sort of come back to 280E if we can. But I also think that this international component is really, really interesting because I think another reason that, well, I know that the discussions amongst the folks in the White House have been around, look, the cannabis industry is global. It's projected by, Whitney Economics to be a $400 billion global juggernaut. You look at, maybe realistically $50 billion in international transactions outside the United States in the lawful international cannabis community. Rescheduling or descheduling will all of a sudden send a signal that U.S. cannabis is allowed to be sold. We see that with hemp already because of the descheduling. But there's some questions about the regulations and the certifications and the quality of those materials. But that would signal U.S., it's okay to participate in this global economy. And it would also indicate that other companies around the world that produce products would want to come and have access in the U.S. to our consumer base. So it creates sort of a whirlwind of activity. Do you think banks are ready to not just address cannabis banking in a de or rescheduled environment, but address international cannabis banking? Because it seems far-fetched. When I talk about the global cannabis supply chain, which I've been working in for almost a decade now, people look at me like a dog that heard a high-pitched whistle in the background. They have no idea that this really exists and that lawful transactions are happening every day and every week. Do you think banks know that? Do you think banks anticipate that?
Yeah, great point. I don't think they've even thought that far ahead. I mean, that's my impression that I have. It might be an unfair one, but I think again, banks tend to be very, very cautious on the risk side, and it's a little bit like it's analogous to cryptocurrency. You're adding a little bit of risk. I think when you're also thinking about international players in the cannabis markets. I think that, but at the same time, if this descheduling does happen, I think this is going to be a huge a huge opportunity for the capital markets, both debt financing as well as capitalization. So I don't think again, I was the first to hear of this this morning when we talked about this potential for actual descheduling, and I do think that that has major implications. I think for cannabis industry, both nationally and, as you say, internationally. And banks need to be forward thinking about this, and they need to be talking about that as well as the integration of crypto and cannabis banking. So I think those two things represent some additional risks, but they also represent big opportunities.
Yeah, yeah, definitely. Lots of opportunity, and I think even in an environment internationally, my observation is that if I am, conducting a transaction from, Morocco and sending the material into Czech Republic, there's still not a lot of banks, even though that's a 100% legal transaction on both sides, provided the compliance pieces are all in place. Banks are still hesitant internationally to touch that because of the fear of the repercussions of what might happen with their affiliate banks here in the US. Which raises another issue. Can the U.S. banks apply a standard of illegality like Schedule One presently towards marijuana and require the same compliance all around the world with other banks when those transactions don't have anything to do with Schedule One and are freed from those restrictions because there is a cogent legal framework for that. But that's another conversation we could have for a whole nother webinar. But let's go back to the 280E concept for a minute, because it's been said that the biggest upshot of rescheduling is that 280E relief would be found. And let me just throw out some numbers here from a friend of mine, Matt Carnes, from Greenwave Advisors. He posted this on LinkedIn the other day, and I've known Matt for a while, so I trust his numbers. He talks about that from 2019 to 2024, there's been greater than 1.2 billion in lost tax savings based on only 12 companies reviewed. 12 companies out of the hundreds or thousands that are licensed in the US. And then he also says that according to one source, there's approximately 1.8 billion in unpaid 280E, including interest and penalties amongst the larger operators, which means those numbers are much larger. So 280E, on its face, only applies to Schedule 1 and Schedule 2 substances. That's what the statute says. In other words, so if it is a Schedule 3 substance, it by its definition does not apply. However, do I have to be a DEA registrant in the event of rescheduling? It's a Schedule 3 substance today. And let's say I am selling cannabis in a state-based system and I'm compliant with the state-based system. Um, do I still have 280E implications if I'm not registered with the DEA as a Schedule 3 operator, even though the substance is Schedule 3? I don't think there's a clear answer to it, but I'd be curious your thoughts.
Yeah, and again, a little bit of knowledge is a dangerous thing, and I'm not a tax attorney. But as you've pointed out, 280E applies to the substance. So I think my view on this is that even if we have rescheduling and these CRBs are working with a Schedule 3 substance, but there's not a regulatory regime in place for them to work because the Food and Drug Administration hasn't promulgated rules, and which will take years, and or the DEA for that matter. There's still going to be some, even though they won't be subject to 280E, they'll still be operating in some sphere of illegality. Now, whether that's criminal or not is another question. But so anyway, there is still going to be going back to the financial institution's perspective, there's still going to be risk involved there because they will be operating in this kind of cloudy sphere of illegality. But at the same time, they are going to be, as I mentioned a few moments ago, they're going to be much better lending prospects.
And I think that, there's also this sort of notion that if 280E goes away, maybe somehow magically it forgives unpaid 280E debt retroactively. But I don't believe the IRS works that way. I don't think the IRS is gonna give up
Yeah.
that booked revenue for them. But more importantly, there have been some cases, and I'm not intimately familiar with the legalities or the legal arguments, but as I understand it, some of the larger MSOs have in fact sued the IRS and sort of retroactively gotten relief on what they've owed under 280E. So I guess that's a possibility as well.
Yeah, I'm aware of that. And the other, thing that is that I should point out is that with if you know with if Schedule 3 does happen, there's going to be some confusion out there, I think, with banks and their CRB customers because even if cannabis does go to Schedule 3, the compliance and the BSA obligations still remain there, and those are pretty onerous. Again, I mentioned a couple of times the FinCEN guidance, and uh, until that guidance gets revised or rescinded, banks and credit unions are going to have to abide by that guidance. And there are, basically three elements to that. There's enhanced onboarding, pretty significant enhanced onboarding, taking on a CRB business, and then there's the ongoing monitoring and due diligence associated with the CRB, and then most burdensome of all are these SAR, the suspicious activity filings that need to be made. So all of that stays in place with rescheduling. And I should also say that I haven't mentioned the Safer Banking Act yet. That's a piece of legislation that has been wallowing in Congress now for years, in one form or another, one version or another, for 8 or 9 years now. But even if the Safer Banking Act gets passed, uh, that doesn't take away those compliance burdens. One of the important sections of that bill are that it will require financial regulators to further delineate what the responsibilities are for banks and credit unions. It'll create greater certainty for banks and credit unions in terms of their compliance and BSA obligations, but it doesn't take away those obligations at all. So that's one potential misunderstanding that could occur. And even with descheduling, that will not occur until FinCEN does something about this 13-year-old, 12 or 13-year-old guidance that they've issued. And they've been pretty quiet. I haven't heard, I don't see them at conferences very much. There was a time when they were here, but haven't heard from them.
Well, I just wanted to mention, just by way of process, right? So if we're talking about rescheduling, um, we've seen this started under President Biden. There's an administrative review, there's a notice and comment, there's a final rule and implementation. We never did get there under the last administration, but we did have the HHS report, the recommendation. Um, the descheduling is a little bit of a different process. Descheduling would require a legislative act by Congress or really a highly coordinated executive initiative that removes cannabis from the CSA, the Controlled Substances Act. So, for example, if the president were to say, we think we support descheduling, Congress would have to act, which Congress hasn't been particularly astute at doing many things these days for partisan reasons and otherwise. So I wouldn't count on cannabis or Congress descheduling or removing it. So it would have to be a coordinated act. amongst a number of agencies. It would have to require HHS to sort of re-examine their position to date. And instead of saying we recommend Schedule 3, we recommend descheduling, and here's why. So those are some things that would have to go through an administrative process. But I think to your point about FinCEN, descheduling also formally triggers broader regulatory adjustments. It's going to have banking, taxation, FDA oversight, interstate commerce examined through those relevant federal agencies before. So it doesn't appear that it's just a snap of your fingers and a magic descheduling event. Those are some interesting things by way of process.
Yeah,
We've got
that
about,
is a
yeah,
Yeah, go
please.
ahead. No, I was just
I
going
was
to say
gonna say,
that's a very important point to make that you've just made. The rescheduling is a much procedurally is a much lower threshold. That can be done by rulemaking with notice and comment, rulemaking without notice and comment, and there is actually also a provision in the Controlled Substances Act which would allow Trump to do that by executive order. And this was just pointed out to me a couple of weeks ago that would direct the Bondi, the Attorney General, to reschedule in I think 60 days time. So a very important point to make about the fact that even if Trump wants to move forward with descheduling, it's certainly not not a given.
definitely not a given. All right. Uh, Running short on time. Let's talk briefly. I just want to comment on if there's rescheduling or descheduling, then it would appear that bankruptcy would all of a sudden be available to these businesses. And at least to date, they've been mostly prohibited from, using bankruptcy protections at the federal level. Although there's been some evolving case law on that, but as a general rule, bankruptcy has not really been an option. Do you think that banks perceive the ability of bankruptcy protection as a greater risk or not as great of a risk as it relates to lending in a rescheduled environment? Is having bankruptcy protection a good thing for someone that's borrowing money for you or not a good thing?
I think it cuts both ways with banks. And again, it will depend on the number of creditors CRB has, where the bank falls in line. But I do think that any bank that gets into cannabis lending, they're going to want to be high up on the priority chain, and they're going to want to be, pretty close to first in line. They're going to want to think about the collateral that they use. They're going to want to be very careful about their ratios, their debt to income ratios, and their loan to value ratios. They're going to want to be very, very conservative with all of that. But getting back to C Trust and what C Trust offers, it does represent a big risk mitigation opportunity for banks and credit unions looking to get into that space by by uh, seeing problems before they become problems. I think that might be a good way of putting it. So I do think that there are tools out there to significantly mitigate the risks. And I should also add that many states do have receivership laws that can be that CRBs can avail themselves of. So.
Yeah, no, and receivership has been sort of the alternative to bankruptcy thus far, and that's a whole nother topic as well. But the gist of it is a court appoints a trustee or a receiver who oversees the business as a fiduciary to the court and to the shareholders and to the public. And it's not always an easy thing to achieve because people are in disagreement about whether they want all of the inside of the company exposed to third
Right.
parties because not every company is doing things exactly by the book, or at least people don't want their decisions questioned. The last question, and then I'll just try to bump off these Q&A questions that are there for the benefit of the audience. Capital markets access, meaning, stock exchanges and whatnot. We saw when the Canadian exchanges opened up, and then subsequently the exchange in Tel Aviv and the exchanges in Frankfurt and London, that there's been these sort of influx of capital. And this industry is always cash starved, or so it seems. I've never met an industry so cash starved. And I sometimes I just frankly don't understand it. It's probably a combination of compliance costs and 280E impact, but the industry always needs money. Do capital markets open up automatically as a rescheduled or a descheduled event, or we don't
I
know?
Yeah, so I have actually talked to a few investment bankers who are already, again, thinking about getting into this space. So I certainly think with rescheduling and descheduling, there's going to be greater interest on the part of capital markets. Uh,
Yeah, and
and
it would
I think
seem.
I think even they're a little bit more forward thinking. We were talking about the international aspect to this. And I think they've been contemplating that, whereas I think the banks have been a little contemplating that aspect of it less.
And I would just note that, all of these topics. So I'm a contributor at Forbes. I've got a three-part series. I'm two parts into it. So for those of you that can't sleep at night, just Google Forbes and my last name Hoban, and you'll see my list of columns there. And I try to speculate as to what sort of the impacts of this might be. Part three of that series, I hope to get out through the end of this weekend. We'll talk about sort of the chaos that could ensue in the event of descheduling versus scheduling. So this is a relevant topic, particularly given where we're at. Looking at some of the questions here in the last few minutes, gentleman, right, or gentleman, someone named Owner writes, can you expand more on the international export, import, or a resource? Bo Whitney from Whitney Economics has responded there. If you're looking for data, there's nobody better than Bo. I would encourage you to reach out to him. I'm also available to talk about international commerce. That's been my world for the better part of the last decade. But if cannabis is all of a sudden federally authorized, then the materials that are sold intrastate right now in the closed loop marijuana systems would be not only allowed to cross state lines more than in theory, although we'd have to see what the states say about that. But you'd be able to put cannabis grown under a federal registration into global commerce. And again, the question becomes, as Chris and I talked about briefly, is how do banks in the U.S. perceive that? And we don't really know, but it's going to come sooner than they expect. Um, what about new studies for medical cannabis? Will rescheduling allow people to study cannabis in school to a more intense degree? It was Obama that opened up, actually, pardon me, it was George Bush, W. Bush, that opened up more access to studying cannabis. Um, Obama expanded on that a little bit. We've still seen people that are in the industry that are applying for grants and applying for research designations getting not denied per se, but we see people like Sue Sisley and her operation, just no action on applications to study cannabis. I don't know if that's the exact case today, but at the end of the day, that's something that we've seen. But yes, in theory, it would allow the expanded study of medical cannabis because it's being recognized formally as a medical substance. Um, the most
Bob,
practical way to start oh, go ahead, Chris, please.
I just want to, and we do want to finish with the questions, but I see that Raphael has put up this giveaway slide, and I don't want to forget this for the benefit of our folks who are listening. We I'll start, Bob, and then you can talk a little bit about yours. But if there are any folks from banks or credit unions out there who are looking to get into this space or who are looking to expand into the lending side, I will make myself available to your boards or your senior management team to talk about my experience in the cannabis lending space, and particularly, I think there's this misconception out there that if a bank or credit union gets into the cannabis banking space, they're going to furrow the eyebrows of the regulators. That is not the case. It's a regulators look on cannabis banking like they look on any other aspect of banks and credit unions. Is the risk being managed appropriately? So I can talk to your boards and credit and your senior management staff about that, and that would be free of charge, no obligation about moving forward and so forth. So if anyone would like to reach out to me, my email, I think, and Bob's emails are going to be at the end of this. Bob, why don't you take over with yours?
Yeah, Chris, thanks for that. And yeah, at C Trust, our specialty is assessing and monitoring risk for banks and for other institutions in this space. So, C Trust provides a credit score for businesses. C Trust can advise and is also going to provide a complimentary 30-minute education consult on cannabis credit risk, on how a bank can establish a lending program, on the tools that C Trust has that banks use and banks will more and more use. C Trust is really the only agency in the United States that does this in terms of standardized evaluation of risk and debt monitoring and the like through various tools that it has. I'd encourage you to take a look at the ctrust.io website for a description of some of those tools. And Raphael, if you want to go to the next slide, this is where you can contact both Chris and Cogent Law and us at C Trust at those emails and phone numbers on that page. And if you have any broader questions that are not specific to C Trust and what Cogent Law does, just more about generally the international marketplace, I'm certainly available as well. And my email is bob@bobhoban.com. This has been really, really great, Chris. And you and I could talk about this for a very long time, but I think that we're just about running out of time here. So I don't know if we want to just buzz through the last couple of questions just to bring this to a conclusion for the
Yeah,
benefit
let's
of the
do that.
audience.
Yeah. And
So
just one last thing, that T. Robinson, that's Ted, Ted
that
Robinson. I
is
know
Ted.
Ted, and I know Ted well enough to know that he will get back to your email very quickly. Ted is a good partner.
Ted is our chief strategy officer at C Trust and an industry veteran as well. And like everybody in the C Trust team, you couldn't ask for better people. Really, really happy to provide that insight. Um, the most practical way to looking at this question, the most practical way to start a cultivation business, that's a really broad question that can't be answered in less than 10 seconds right now.
Yeah.
But
I can give
community
two
and state
cents.
chartered banks.
Yeah. So, if you're just forming a CRB, a cultivation business, and you don't have a established track record, there's no question about it. It is going to be difficult for you to get financing. Most banks and credit unions are looking for some kind of financial track record. They're looking for a to make sure that you've got a good financial acumen behind you. I've always been an advocate of, cares for compliance, a bank on the depository side for a little while. And, if you're good on the compliance side and the bank can see what your revenues are, then I think you become a more attractive prospect on the lending side.
But the takeaway there, I believe, is that startups rarely get funded in this
Yeah.
space. Not anymore. There was a time years ago when that was the case, but you do have to have that track record to get going. So it becomes a family and friends raise by and large to get things going. Um, do we think social justice and legalization or rescheduling is going to affect those who are still incarcerated? Um, that doesn't appear to be a Republican-based priority. I'm not saying it's not. I don't stand for the Republican Party. I'm agnostic politically. I'm just sort of reporting it. The talking points from the Democrats have historically been social justice based around cannabis. The talking points from the Republicans, those that do support cannabis reform or legalization, have primarily been state rights, individual freedoms, and business. So there does not appear to be a cogent pathway towards releasing people. And in fact, if you look at what's happened in the states that have legalized, it's been up to their mayors or their district attorneys or their governors in several instances to go out and put the political cap on the line and say, let's release cannabis-based. And that's one of the things that Biden had made a priority as well. And then last, Does Wall Street and Forbes feel more relaxed to associate with the cannabis industry with particular companies? Do they recognize their unique investments in diverse markets? Um, yeah, I think that there's been a number of institutions on the sideline waiting to get into cannabis, waiting to lend in cannabis. It's banks, it's the whole conversation we've been talking about, and invest in cannabis, but they've been unwilling to do so. I can tell you firsthand in my law practice, I've had dozens upon dozens of companies say, examine the risk for us. And we examine the risk, and they say, well, we're going to wait until there's some federal authorization, which hasn't happened. But many have jumped in with the federal authorization behind hemp. So I don't think that rescheduling or descheduling will be any different, in my opinion. So, Chris, you've got the last word here, my friend.
No, I think that you've answered that question 100%. I just really, we've gone over our time. I want to thank everyone for joining us today. But Bob, I want to give a particular shout out to you. It's been an enormous privilege to talk with you. And yeah, I really do look forward to doing this again with you at some time. I hope our attendees have found the webinar worthwhile, and please do not hesitate to reach out either to me, there's my email, or to Ted Robinson at C Trust. If any additional follow-up questions, or if you want to take advantage of those takeaways that Bob and I talked about a few moments ago. Thank you so much, everyone, for joining us. And Bob, thanks again.
It's been my pleasure. Thank you.